Hello and welcome to Competology Academy. And today we are going to discuss the second part. This is going to be the second lecture in the series of Santhal Pargana Tenancy Act. And here today we will discuss the section chapter 3 from section 12 to 20. So the chapter 3 is the largest chapter in the Santhal Pargana Tenancy Act, and because of that we will go section by section, part by part, and thereafter we will go to the next chapter. So those who have not subscribed the channel till now, so they should go on to subscribe the channel and press the bell icon to get notified whenever we are live or whenever we will upload new videos, because this part is going to be very important. And in the first video I have already discussed about the importance of the Santhal Pargana Tenancy Act from the point of view of that Jharkhand Public Service Commission exams. So just don't waste the time and go on to discuss the chapter. So here the chapter 3 is related to the riyads, those landholders, those people who hold the land on tenancy as a tenure holder, and they are entitled to cultivate their land, but they have to pay the taxes, the land revenue, to the landlord, to the government, whoever is working as a landlord, whether he is a village headman, mul rayyat, landlord, or some kind of government official, so whatever it is. So here section 12 it says that there shall be the following classes of rayyats. So different classes of rayyats are there. The rayyats are classified into different groups, and here the first group is resident jama bandi rayyat. So those rayyats who are residing in the village and they have their land in the perimeter of, under the boundary of that same village, and their name is mentioned in the record of rights. So those people will be considered as the resident Jamabandi Rayyats, because they are residing within the village, they have their land holding within the village, as well as they live with their family within the village itself. Next is non-resident Jamabandi Rayyats. So those Rayyats who are having the land in the village, but their family and they do not live in that particular village, but they have their name mentioned in the record of rights with respect to the land holding they have in that particular village. So they will be considered as the non-resident Jamabandi Rayyat. And here one more thing is that you will find there, even nowadays the people are having their land holding in different villages, different areas. So at that very time even the population was less and the availability of the land was more. So even the tribal people and the landlords and everybody was having too much of land, and that was spread out in different villages. That was having, they will have one particular village, their ancestral village, and the land will be in different villages. So wherever there was a land holding for them and their name was in the record of rights, but they were not residing in that village, were called as non-resident Jamabandi Rayyat. Thereafter, there are new rayyats. So those persons who are recorded as new rayyats with records of rights, with respect to the record of rights, whose name has been entered, whose name has been added to the record of rights in the recent updated record of rights. So they will be called as new rayyats, right? Now come to section 13. So here section 13 says that a rayyat may use the land under his holding in a way that is authorized under the local customs and traditions, or in a way that is unexpected by the local customs and traditions, but that does not destroy the value of the land or does not make the same unsuitable for cultivation. So all the rayyats who are having any holding are allowed to cultivate their land, allowed to use their land even for the orchard, for the construction of pond, whatever it is, which is allowed by the local customs. वहाँ के जो गांव के नियम कानून है, according to that they are allowed to use their land, right? And even Apart from that, they can use the land for different purpose also, which is not expected according to the local customs. But that methodology of use, that purpose should not destroy, should not reduce the fertility of the land, should not make it uncultivable, render it unfertile, so that their production will go down. And if such a thing happens, then he can be evicted from his land, right? So the eviction process and the other things we will discuss in the coming chapters. First of all, we go through the section by section about the definition of the riyads, their rights, their entitlements, and the other things. Section 14 says that a riyad shall not be evicted or ejected from his holding by the landlord without an order of the deputy commissioner. So in any case, if a riyad has to be evicted from his holding, if he is not using the land according to the rules and regulation, if he is not paying the land revenue in a time bound way, then in such case he can be evicted from his land. But such an order for his eviction can be passed only by the deputy commissioner, DC, and the landlord does not have the power with himself that he can evict the rayat from that land. So here he have to make a application to the DC that this person is not uh, fulfilling the required norms and not following the terms and conditions of the use of land. He is not paying the rent or whatever it is may be the circumstances under which he have to be evicted. So such thing should be mentioned in the application. His case will be filed in front of the DC, and thereafter DC, after hearing both the parties, will pass the order for the eviction of any rayyat. Next is section 15. Here section 15 says that a rayyat shall have a right to use his holding for making bricks, tiles for his own use without any license fee. So even nowadays you will find some of the people go on to make the brick of their own use by in their own land. So they are allowed to do that without taking any commercial license or without taking any permission from the authorities. But they cannot use that brick or tile for commercial purpose. They cannot sell it, but they can use it for their own construction purpose, right? Next is section 16. It says that without any specific permission from the landlord, a rayat may build or develop embankments, ahars, ponds, wells, etc. within his holding or settlement land, provided that the same does not result in any damage to anybody else. So the first part says that for the purpose of irrigation or for any other purpose, if a person needs to construct any source of water conservation, water drawing, or that of water storage like the pond, the ahar, आजकल के टाइम में जो गवर्नमेंट चला रही है जिसको क्या कहते हैं डोभा, like so such kind of things, even the wells etc can be dug on his land, but that should not damage or that should not result in damage to anybody else. So you cannot construct a pond in such a way that the other person's land gets eroded away, उसका जमीन न बह जाए, उसकी मिट्टी न बह जाए बगल वाले की, तो ऐसे भी आपको कंस्ट्रक्शन नहीं करना है. इट इज नॉट अलाउड, right? The second part says that in the case of actual damage or potential damage, the DC shall take the appropriate decision. So in case if you have constructed any of the pond, any of the ahar or something like that, which is causing any damage, any problem to the adjoining landholders, adjoining rayats who are having their holding around your land where you have made this construction, then a complaint can be filed to the DC, and in such cases the DC will pass appropriate decision, whether it is a compensation, whether it is an order that you should now fill up the pond or whatever it is according to the need. The rayat may use such water bodies for fish farming or similar activities without paying any fee. So on such water bodies the rayat can do the fish farming also, right? Next is section 17. So here in section 17 it says that A rayyat may plant trees, orchards, bamboos, or any on any land of his holding and cut it, fill it, appropriate the same. So the rayyat is allowed to harvest the products through the orchard, through the bamboo growing process, or any of the other plantation process on his righty land. And he can also appropriate it, he can also sell it in the market, but that can be appropriated. However, no mahua tree shall be cut without the permission of subdivisional officer. So why there was a specific mention of mahua tree? Many of you can recognize it quite easily, that even today mahua is a very commercially viable tree. Like the flowers of the mahua is used for various purposes, like cattle feed, right? इवन फॉर मेकिंग द कंट्री लीकर, महुआ हड़िया ये सब जो है आजकल भी झारखंड में बहुत पॉपुलर है ना. तो at that very time also it was very popular, and the government was getting good revenue out of that liquor sale from the liquor shops, right? And that is why the subdivisional officer's permission is needed to cut down any mahua tree. Even the fruits of the mahua are very precious item, that is a good source of edible oil, right? So low quality edible oil can be extracted from the fruits of mahua also. Even the unripened green mahua fruits are used as vegetable also in the village areas, right? Now there is next point, that he shall have the right to grow the lac, rear the silk cocoon free of charges on the trees planted by him on his holding. So he can do the cultivation or the harvesting of lac as well as silk cocoon also on his holding. So these kind of utilities, this he can use his holding for such purposes, right? Section 18, here it says that a rayyat may erect the kacha or pakka building on his holding for him or his family members, domestic or agricultural purposes. So section 18 says that he is allowed to construct any of the kacha or pakka building, makan जो भी होता है ना, or even in the farmland he can construct the building for the storage purposes like that of the agriculture purpose, and nobody can restrict him from doing that, right? Now come to the next point. Here it says that section 19, and it is again a very long section. There are various subsections under it, various points are there, and it becomes very important from the exam point of view, because from this section related to SPT you will get the questions from the subsections also, right? So here let us discuss it. Division of holding and distribution of rent. So in case if a holding is being inherited by the successors of a person, by the son, two or three son of a person, a farmer, a rayyat, then in such cases that holding will be divided between them according to the local customs and other things, as well as there will be division of the rent that will be payable by the successor rayyats, the son of that rayyats. So here the first point says that a holding may be subdivided and the rent thereof distributed with the consent of landlord and the village headman or mul rayyat if any. So for the division and distribution of land as well as the rent, the consent, prior consent of the landlord as well as the village headman or the Mool Rayyat, if any, if they are present, is required. Without their permission, the division of the land cannot be done. Right? Now, when a holding has been the subject of partition or subdivision by an order of court or otherwise, and if the parties to the partition are unable to distribute the rent of the holding by agreement amongst themselves and with the consent of the landlord and the village headman or mulrayyat, and any of these parties may apply to the DC for the distribution of the rent of the holding. So suppose that two of the brothers come in dispute for the partition of the land, and they move to the court, they file a civil suit that हमको जमीन नहीं दे रहा, हमको कम दे रहा है, दे ही नहीं रहा, भगा दे रहा है. Such kind of issues arise every now and then. So in these cases, what happens? The civil court gives the verdict that this much land will be yours, this much land will be yours according to law. So the court order will be there for the partition of the land. Now again the next question comes that now after this partition with the order of court, how much rent will be payable by each of the parties who were the parties of the dispute earlier when they were in the court for the partition suit. So in such case, again they will go to the jamindar, that landlord, and the headman and the mul rayyat, and they will discuss among themselves that what amount of land rent should be payable by each party who have succeeded or who have get the land. But in case if they do not come to any agreement, they will go to the district commissioner. So any of the party, whether the people who have succeeded the land, who have inherited the land, or the village headman himself, the landlord, the village headman, or the mul rayyat, any of them can file a complaint to the DC that please fix the rent on this portion of lands, right? So this will be the process for the fixation of the land revenue on any of the land which had been partitioned, because already शुरू से dispute में ही चल रहा है. There was a dispute for the partition, thereafter there will be a dispute for the rent also, definitely. So again the dispute will be resolved in the court of DC. Subsection 3 says that no case shall a holding be subdivided if the rent of any portion of the holding is less than 3 rupees. But this section is not so viable, or even it is not followed in letter and spirit at a present time. Earlier it was being followed because land revenue was a major issue, and for that matter the land revenue on which any portion of land, if there is land revenue that is applicable, that is less than 3 rupees, then the piece of land become very small, and it becomes that not, it is commercially not viable. And that is why there was a limitation that all those holdings on which the land revenue, the land tax that is applicable is less than 3 rupees, so such land cannot be partitioned among the successors of any rayyat, right? It will remain as it is. आजकल ये फॉलो नहीं होता. आजकल तो लोगों को 65 पैसा 17 पैसा 5 पैसे का भी रसीद कटता है ना. सो दैट इज द मालगुजारी. इन द हिंदी टर्म्स इट इज कॉल्ड एज मालगुजारी, राइट? नाउ कम टू section 20, the transfer of rayyat's rights. So the transfer of the rayyat rights can be done in many ways, through succession, through sale, through gift deed, or whatever it is. So we will discuss one by one. Subsection 1 says that no transfer by a rayyat of his right in his holding or any portion thereof by sale, gift, mortgage, will, lease, or any other contract or agreement, express or implied, shall be valid unless. So in any case the transfer of the rayyat's rights will not be valid if they do not fulfill these conditions. So what are the conditions? First condition is that right to transfer has been recorded in the record of rights. So when the record of rights is compiled during the survey, even आजकल वही झमेला चल रहा है 1932 का खतियान, 1932 का खतियान, because in Jharkhand after 1932 the survey have not been done. After that the record of rights have not been updated, and that is why it is a big issue. Now if the record of rights had been updated and there was a column in which it was mentioned that whether the rayyat have the right to transfer his land or he does not have the right to transfer his land, so he can transfer his land by any of the mode, by sale, gift, mortgage, will, lease, or whatever it is, only when if the right to transfer is mentioned in the record of rights, it had been updated in the record of rights during the compilation of the record of rights. Next point is, a lease of a raiti land in any subdivision by a rayat for a period of not exceeding 1 year, not exceeding 1 year, may be allowed with the prior written permission of the DC only. So many of the raiti lands were being kept in mortgage or on given on the lease to the money lenders or to the wealthy farmers, and this was causing the alienation of the tribal land. And to restrict such kind of alienation of tribal land, it was mentioned in the documents of the SPT Act itself that they cannot give any land that is not exceeding 1 year to anybody on lease without the prior permission of the DC, so that the alienation of the land of the tribal people can be restricted. Next is, where the gifts by a recorded Santhali Rayat to a sister and the daughter are permissible under the Santhal law, such a Rayat may validly make such a gift with the prior written permission of the DC. So in many of the Santhali tribal community, there was a trend, there was a thing that they can give their land to their sister as gift or their daughter as gift, because earlier the property right was not there with the women. So it was a very different kind of situation. Now under the Hindu code bill, the women are also having the property rights, they can inherit the ancestors right property, but during that period they were getting such kind of things only through gift. So if under the Santhal law it is allowed that they can gift their land to their sister or daughter, and if it is mentioned in the record of rights and it is allowed according to the local customs, then also they can do this thing only with the prior permission of the DC. In such case also they need the permission of DC, right? Now next is, an aboriginal rayat may with the prior permission, written permission of the DC, make a grant in respect of his land not exceeding one half of the area of his holding to his widowed mother or his wife for their maintenance after his death. So suppose that there is a Santali women who is widowed, and if his son wants that he should give some of the land, because land is the main source of income, and at that very time it was the only source of income for the tribal people. So in such case, if the son wants that to ensure the good livelihood resource for his mother, if he wants that he should give some of the portion of his land, then he can do that, but with the prior permission of DC, and only half of his land can be gifted to his mother. And in same case, if the person thinks that after my death what will happen to my wife, from where she will get her livelihood, then in such case also he can gift his that land to his wife also, but in such case also again the permission of the DC is needed, as well as not more than half of his holding can be gifted to his wife. So these were the conditions, right? Now the next subsection says that notwithstanding anything contrary contained in the record of rights, right? So whatever is written in the record of rights, whether it is mentioned that he can transfer his land or not, whether he has the right to transfer his land or not, here no right of an aboriginal rayat in his holding or any portion thereof which is transferable shall be transferred in any manner to anyone but an aboriginal rayat engaged in bona fide cultivation of the Pargana or Taluka in which the holding is situated. So here, even if the record of right mentions that Rayat can transfer his holding to anyone, but he can do that only to a tribal person, Santhali tribal person. That means that what? He can transfer his holding to the tribal person, but that too, the person who is residing in the same village, same taluka or pargana, as well as he is a farmer, he is a bona fide cultivator. So they cannot transfer their land, they cannot transfer their holding to anybody who is just a commercial businessman or whatever kind of thing, but they can transfer their land only to a person who is willing to cultivate the land in future, right? And nothing in this subsection shall apply to a transfer made by an aboriginal rayat of his right in his holding or portion thereof in favor of gardi jamai or ghar jamai, right? So here again a new term, that is gardi jamai or ghar jamai, comes. So in the tribal society there is a culture that if they marry their daughter, then in some cases what happens, their son-in-law comes to reside in the home of, in the village of, that of his father-in-law itself. So he is known as gardi jamai or ghar jamai. So in such cases, if there is a ghardi jamai and or ghar jamai, then nothing will restrict the father-in-law to transfer the land in his name. He will get the land transferred to his name by itself. Next is, besides this, as per the Santhal Pargana Tenancy Act, Supplementary Provisions Amendment Act 1975, so this amendment was introduced in 1975. A Rayyat who is a member of Aboriginal tribe or Aboriginal caste may, with prior sanction of the DC, and a Rayyat who has who is a member of the Aboriginal tribe or Aboriginal caste may, without such prior sanction, enter into a simple mortgage in respect of scheduled commercial banks or with his holding, meaning of the Reserve Bank of India Act 1934, or any society or the bank registered under Bihar and Odisha Cooperative Societies Act, or a financial institution which is owned by a government. So this provision was inserted after an amendment because most of the tribal people were unable to get the loan from the banks, right? Because if in case they are unable to pay the rank, they pay the loan, then in such case what used to happen, the bank were unable to sell their land, auction their land to anybody, because their land can be sold to a person who is a tribal, who is residing in the same taluka, who is residing in the same village. So in such cases most of the scheduled commercial banks were unable to auction their land. Even nowadays they are facing such kind of issues, but at that very time, even in the act itself, it was mentioned that they cannot mortgage their land, they cannot mortgage their or lease out their land without the permission of DC. So even to get the loan, the tribal had to go to the DC office that we want to take the loan, and for that purpose we have to mortgage our land to the scheduled commercial bank or whatever it is. So there were too many paperworks which the tribal people don't understand. At that very time the literacy rate was also very low in the tribal community, so they were facing various issues, and they were getting trapped into the hands of the money lenders, local money lenders. So to ensure that they should not get exploited in the hands of local money lenders, this amendment was introduced in 1975, that they can get the loan from scheduled commercial banks, societies, right? Thereafter the government owned banks like regional rural banks or whatever it is. So this person is allowed to transfer his land, or this person is allowed to sell his land. So it should be mentioned in the record of rights, right? Now the next subsection says that as per the Bihar Act of 1976, a holding or a portion thereof held by an occupancy rayat may be sold under the procedure laid down in the Bihar and Odisha Public Demands Recovery Act of 1914 for the realization of loans taken from any of these banks. So again the case is same: the scheduled commercial bank, the societies, the bank registered under the Societies Registration Act, thereafter those institutions which are owned by the government. So here again it says that all those banks which are scheduled commercial bank under the definition of RBI, those regional rural banks, or any of the financial institutions which are owned by the government, or those banks or the societies which are registered under the Bihar and Odisha Act 6 of 1935, they can realize their loan by sale or auction of the mortgaged land under the Bihar and Odisha Public Demands Recovery Act of 1914. So again this was to ease the sanction of loan, to ease the allocation of loans to the tribal people. Now here next point says that, but if the holding or portion thereof belongs to a Rayyat who is a member of aboriginal tribe or aboriginal caste, it shall not be sold to any person who is not a member of the aboriginal tribe or aboriginal caste. So now again the same issue arises, that in case of the realization of loan also, again the land can be sold only to a person who is the member of a tribal community, an aboriginal tribe or aboriginal caste. So the land can be sold to the people who belong to the same community only. So again if the bank even give forwards the loan, and if the bank have to recover the loan, then they will face again the same issue. ऑक्शन जमीन करने जा रहे हैं और उसमें पूछते चल रहे भाई ट्राइबल हो तभी दे सकते हैं. So that will be again a big issue for the bank, and even at present time also the banks are reluctant to forward the loan to the tribal people because of these same issues, that in the case of that loan is not being repaid in a timely manner, and if they have to recover the loan through auction, then it becomes a Herculean task for them to realize their loan, right? So this is again a big problem. Next is section 5, subsection 5. In fact, if at any time it comes to the notice of the DC that the transfer of the land belonging to a Rayyat who is a member of scheduled tribe as specified in part 4 of the schedule of the Constitution Order 1950 has taken place in contravention of subsection 1 and subsection 2 by any fraudulent method, he may, after giving reasonable opportunity to the transferee to sow cows and after making necessary inquiry in that matter, evict the transferee from the land without payment of compensation, and that land will be restored back to the transferor or his hire. So in this subsection it mentions that if the subsection 1 and subsection 2 were violated, and the person who was a scheduled tribal person who is mentioned as a scheduled tribe in the uh, Constitution of India, and his land has been transferred in contravention of subsection 1 or subsection 2, then in such cases what will happen? The DC will order the eviction of the transferee, the person who has received the land, and that land will be restored back to the transferor without the payment of any compensation. Doesn't matter what amount he had paid before getting that land transferred in his name, right? And that land will be restored back to the transferor or his hire, or in case the hire is not willing to avail that restoration of land to such case, then he will resettle it with another rayyat belonging to the scheduled tribe according to the village customs. So in many cases what happens, if some musalman, कोई दबंग आदमी अगर ट्राइबल लैंड खरीद लिया है, and if the DC wants to restore back that land to the original tribal person who was the owner of the land, who is the transferor, then they may be reluctant that अगर हम वापस ले लेंगे जमीन, then this musalman will threaten us, will harass us. So various issues are there. So in such cases, if that person is not willing to take back the land, then the DC is allowed, DC is entitled to resettle that land to any other person who is the member of tribal community. Right. Now, if a transferee has within 30 years from the date of transfer constructed any building or structure on such holding or portion thereof, and if the transferor is not willing to pay the value of the same, so अगर ये पिक्चर में आता है, if it comes in picture that the transfer of the land was made in contravention of subsection 1 and subsection 2 of this SPT Act of section 20, then the transferee will have to evict the land, and the land will be restored back to the transferor. But in case within 30 years of transfer, if some kind of construction, some kind of building or something like that had been erected on that land, then in such case what will happen? The DC shall order the transferee to remove the same within a period of 6 months from the date of the order of eviction. First of all, the DC has the option that he will order the transferee that you will get the compensation, and he will order the transferor that you should pay this much of money to the transferee for his construction work, what he has erected on your land, and you can take it. But many of the people, हमको नहीं चाहिए अपना घर उठा के ले जाओ. So in such case what will happen? The DC will order, DC will not allow the person to take an undue advantage to the transferor. DC is again entitled that he will say the transferee to remove the construction within a period of 6 months, so that the transferor should not get any undue advantage. Otherwise क्या होगा? What will happen? Many of the people will go on to sell their land, and if some construction has been done, thereafter they will claim that this is a tribal land and give me to back to me, और फ्री में कंस्ट्रक्शन मिल गया. ठीक है. So such kind of things should not be done. And if the transferee is unable to remove, then what will happen? Within such extended time not exceeding 2 years from the date of the order, as the DC may allow, extended period of 2 years time will be allowed to the transferee to remove the construction work. And even after that, if the transferee does not remove the construction work, then the DC may get such building or structure removed by himself. फिर सरकारी बुलडोजर चल जाएगा, right? So this will happen. Next is where the DC is satisfied that the transferee has constructed a substantial structure or building on the holding or a portion thereof before coming into force of the Bihar Scheduled Area Regulation Act of 1969, then he may, notwithstanding anything, any provision in the act, validate such transfer. Right. So if the transfer had been done before 1969, then the such transfers can be validated by the DC, but there are again conditions. The transferee either makes available to the transferor an alternative holding or a portion thereof, just adjoining plot you can give him to the person who had transferred the land, that take this one and I will take this one, right? Or as the case may be of an equivalent value in the vicinity, or even he can pay the monetary compensation that is adequately determined by the DC, that this much of the compensation for the person is sufficient. You can pay this much of the compensation to the transferor and you can keep the land, right? So again, this is a provision. Next, here what it says, If after an inquiry the DC is satisfied that the transferee has acquired a title by adverse permission, possession, and that the transferred land should be restored or resettled, then in such case he shall require the transferee or his hire or another rayat, as the case may be, to deposit with the DC such sum of money as may be determined by the DC, having regarded to the amount for which the land was transferred or the market value of the land, as the case may be. So if in any case the land was sold by the person, by the tribal person, and if the DC says, witnesses that he observes that this transfer was in contravention of subsection 1 and subsection 2 of section 20, and if he thinks that this person should be evicted from this adverse possession of the land because this is a tribal land, so in such case, if the land was sold, then the DC will order the transferee to deposit, not the transferee but the transferor to deposit a sum of money that will be determined by the DC for which the land was transferred or the market value of the land to the DC office, and the amount of the compensation for the improvements effected to the land which the DC may deem fair and equivalent, and thereafter, after the deposit of such compensation, that land will be restored back to the transferor. So here we finish off section 12 to 20 of chapter 3 of Santhal Pargana Tenancy Act, and if you watch the video till the end, then please consider subscribing the channel and press the bell icon to get notified whenever we will upload the new videos or whenever we will be live, then you will get the notification. And here you can also follow us on our Facebook and Instagram handle. This is our Telegram channel from where you will get various things, the study materials and the other things. You can also download our app that is available on Google Play, and here you will get the current affairs magazines in both the languages, Hindi and English. The link for the app is provided in the description box below, and we have various study materials that you can purchase in a frugal amount of money. Those are very cheap amount, and those are available in our app also, in on our website also, as well as you can also contact us directly so that you can place the order for those books, right? So here we finish off. Get back again tomorrow for the discussion of the next part of the SPT Act. Thank you very much and have a nice day.